All right, everybody, welcome to our webinar today. For those of you who don't know me, my name is Jessica Summers. I am a principal here at Lurch, Early and Brewer. Happy to see some familiar names on our attendee list today. So for those of you who don't know me, my specialty is in employment law. Those of you who do know me, you've probably been on one of my webinars before. So hopefully we can make some progress today in understanding what's going on with non-competes and answer any of your questions. As we go through, if you do have any questions, there is a Q&A button at the bottom of your Zoom window that you should be able to click on, ask me a question. If they fit in naturally in the flow, I will move over to questions as we go through. If not, I've got left some time at the end for questions. So without further ado, let's kick things off and I will share my screen. The slides will be circulated to everyone after the presentation, since I know that was going to be the first question everyone was going to ask. So just to give you all a little bit of a roadmap of where I'm hoping to traverse today, starting out just to talk a little bit about what restrictive covenants are, non-competes being a subsection category in there. I know some of you have worked with me on restrictive covenants before, have some expertise and experience in the area, but want to make sure we're all on the same page, talk about some of the considerations that come into play when we're using those restrictive covenants, the historical treatment for enforcing restrictive covenants, and then, of course, legislative proposals, evolving state law, and the new FTC rules that come into play with the non-competes, and then going over some key takeaways. So obviously the genesis of this presentation was the new rules that have been released on the FTC non-competes. Don't worry, we will be diving into those today. But this is all part of sort of a larger conversation that's happening with respect to restrictive covenants across the country. In 2021, the Journal of Law and Economics reported that about 18% of American workers are subject to a non-compete agreement, and that's pretty significant. Generally, with the increased mobility of American workers, there has been more pushback over the last decade or so about non-competes and the enforcement of non-competes, and really sort of balancing the protection of the business and the business interests and the customer relationships with the ability of employees to move around, given that unlike prior generations, particularly some of the younger generations, are not staying at their businesses, at their careers for decades and decades. They're moving around quite a bit. So what is a restrictive covenant? Let's talk about that first. A restrictive covenant is any type of agreement or a clause that might be found in a larger agreement that limits what the employee can do either during their employment or after their employment. And sometimes it is both during and after their employment. Typically, we see a restrictive covenant either be in its own standalone agreement or as part of a larger employment agreement, or perhaps if you're promoting someone, you might give them a restrictive covenant. We do also see them in other forms of agreement, like a stockholder, shareholder agreements, severance agreements when someone is leaving the entity, or an asset purchase or business sale agreement to restrict what happens to the prior owners or prior employees who may be leaving and selling the business. So there's really a few sort of categories within the restrictive covenant world. The first that most people are familiar with is non-competes. Non-competes are going to be a provision that restricts the employee from going to work for someone else or going to perform a certain type of work in an area or in an industry. So that would be, you are the medical provider and you say to your nurse, you cannot go work for another doctor's office in the 10-mile radius around us. Or you're an ad agency and you say, you can't go work for our competitor across the street for 6 months after you leave our employ. The next type of restrictive covenants are non-solicits, and those can come in a couple different ways. Those could be customer or client non-solicits, basically saying, once you leave, we don't care who you go work for, but we do not want you to be soliciting our customers or clients that you developed a relationship with while you were working for us. Or they may be employee non-solicits, also known as anti-rating provisions. This would be, once someone leaves, we don't really care where they go or what they do, but we don't want them coming back and trying to recruit all our employees to go work with them at their new business or work with them at the new company that they're working for. And finally, there's non-disclosure agreements. These tend to be the most benign restrictive covenants when it comes to the scrutiny and restrictions that are being placed on restrictive covenants these days. Non-disclosures really are what they sound like, confidentiality provisions. So telling employees that they can't disclose certain types of confidential or proprietary information about the business that could give someone else an advantage down the line. So just from the setting the stage again, some of the key considerations when we're using restrictive covenants, we don't want to be just willy-nilly using a standard form for all employees. For any of you who've worked with me on these before, you've heard this spiel before as far as pushing employers to really think about what you're trying to protect. Because even if the non-compete or the restrictive covenant you're trying to use isn't strictly prohibited by the jurisdiction where you're functioning, you still have to go before a court or an agency to try to enforce it in the event that there is an issue. So you want to make sure that you've really thought through and made this a customized process in trying to figure out whether a restrictive covenant is appropriate. So first, thinking about what is the business trying to protect and protect against? Are we concerned that someone has, this unique expertise and they're going to go open shop next door and take away all our business? Or are we concerned that they're developing the client relationships and that's where the value is? Or is it really that we're just worried that they have our confidential information and we don't care where they go work, we just don't want them using it? So really giving thought to try to figure out which type of restrictive covenant is appropriate based on what it is we're trying to protect. And then thinking about the duties and responsibilities of the individual position. Our administrative assistant might have one type of information where our salesperson might have another type of information and senior executive might have another type of information. And not all of them it's not going to be appropriate to use the same type of restrictive covenant for all of them. I often see people having agreements for even the receptionist has restrictive covenants in it. The question is, well, why do you have restrictive covenants in, dealing with client solicitation with the receptionist? Is this realistic? Does the receptionist have information about your clients? Does the receptionist have relationships or financial information? So really understanding what the position is and what they're going to have access to. And then combining that to think of what's reasonable and necessary. Do we need to tell someone who's working as a junior level person that they can't go work anywhere in the District of Columbia doing the same thing they're doing for us? Probably not. That's not really necessary to protect our interests, but maybe we do want to restrict them from using some of our information or from working with certain clients. And then, of course, the big elephant in the room is, can we offer a restrictive covenant, this type of restrictive covenant that we want to, based on federal law and state and local law. So we're looking at where the employee is located and then looking at both state, local, and federal law. And as I said, restrictive covenants should not be a one size fits all. They shouldn't be a standard, in all the employment agreements for every single person who walks in your door that has the same type of restrictive covenants. You really want to give it some thought to determine what the appropriate use is. So really, historically, the enforcement and the question of whether a restrictive covenant is enforceable has been a matter of state law and typically common law. So that means law that's derived from the courts as opposed to from a statute. So there would be silence in the statutes and laws of a state as to whether or not you could have someone subjected to a non-compete agreement. And it would be a matter of going before the courts of the state to argue that the non-compete agreement is enforceable. And over that time, the state courts basically created common law in order to determine when a provision or restrictive covenant will or will not be enforceable. So just because there is not a statute in your jurisdiction does not mean that there's not going to be law applied and there's not going to be questions asked about whether your restrictive covenant is enforceable. So historically, courts looked at a number of factors when determining whether a restrictive covenant would be enforceable. That included, what the covenant looked like, the nature of the covenant. Is a non-compete, is a non-solicit, non-disclosure, what's the employee's position, all of these items I was talking about when you're considering offering someone or providing someone with an agreement that has a restrictive covenant, these are the same types of considerations a court is going to look at if they're being asked to enforce a restrictive covenant. And then looking at what's reasonable as far as the time and the geographic scope. We don't want to overshoot with restrictive covenants, because then there's a chance that the court will shoot them down and say, no, these aren't going to be enforceable because you're a business that's based one location in Fairfax, Virginia. Why do you need to be preventing this employee from doing work in Philadelphia, Pennsylvania? So really making sure that there is this narrow tailoring to protect a legitimate business interest, so you're not running into problems with the court. So there's been evolving state laws in this. I mean, historically, the state laws that were on the books limiting restrictive covenants were really industry specific. There are some interesting ones that a lot of the broadcast, there was a lot of laws on the books as far as restricting broadcast journalists or broadcast personalities, making them subject to non-competes, or doctors or lawyers, making them subject to non-competes. The idea being that these people have unique skills and you want them to freely move around. But more recently, there has been an increase in statutes that address some types of restrictive covenants and for all industries. So focusing on non-competes or non-solicits, not just for a specific industry, but in general. And then also looking to expand those restrictions or expand those provisions, not just to agreements with employees, but also agreements with independent contractors. So we've been seeing a growing trend of states that are getting into the midst of restricting the use of restrictive covenants. Most commonly, we're seeing those restrictions coming into play with non-competes. So they're looking to put restrictions on non-competes. Some have gone as far as to place restrictions on the use of non-solicitation agreements. Generally, the restrictions do not extend to properly drafted non-disclosure agreements. Those are usually pretty safe under state law. But we still want to be careful, as I'll talk about in the context of the FTC rules. You want to make sure that what you're calling a non-disclosure agreement is in fact a non-disclosure agreement and is not essentially operating as a non-compete. Now, the way that the states are doing this really varies. Some are looking at, how much someone is making as far as a threshold. Some is looking at whether they're exempt or non-exempt under the overtime rules to determine who it's appropriate to have certain types of restrictive covenants, who can still have them, who we're going to prohibit it. And then some states, California being the most notable example, just have a flat out ban on non-competes. So a few cautions as we're talking about just the state portfolio. Some jurisdictions, including notably for us here, Virginia, have penalties associated with just having an employee sign the agreement. In most jurisdictions, the way the laws are structured, the consequences of having someone sign a prohibited restrictive covenant, so a prohibited non-compete or a prohibited non-solicitation agreement, the consequences is just going to be that you can't enforce that agreement. So you can have someone sign a non-compete agreement in Maryland that violates the Maryland law. It's just not going to be enforceable. You're not going to be able to do anything with it. But in some jurisdictions like Virginia, just having someone sign that agreement when they're prohibited from signing that agreement under the statute triggers penalties. So you want to be really careful to make sure you understand when you're asking someone to sign the agreement, is this an agreement we genuinely are permitted to have? And some states do allow a collection of attorney's fees and costs in the event that either the employee has to sue to try to get a declaration that this agreement you've asked them to sign is null and void, or that they have to defend against an effort to enforce a prohibited, not restrictive covenant against them. And just, one additional note, for those of you who are in businesses that, in the private sector looking to sell, having prohibited agreements can really be seen as a barrier or potential liability. So you want to be really careful, particularly going forward as we're seeing more restrictions, because we have seen that come up in the audit context of a business is looking to sell, but has a bunch of prohibited non-competes or problematic non-competes or restrictive covenants. That can be an issue that can impact the negotiations. So as far as the state laws, before we move off them, just want to give you this as a resource. We do have restrictions in Maryland, DC, and Virginia as to who you can ask to sign a non-compete. Maryland prohibits non-competes for employees who are making at or below 150% the state minimum wage at the time. That varies depending on the size and what year we're talking about. DC has a pretty restrictive law. It basically blanket prohibits non-competes except with highly compensated employees. For the purposes of DC law, highly compensated employees are employees who are making over 150,000 if they're not in the medical field, or over 250,000 if they're in the medical profession. And then Virginia prohibits employees making less than a set threshold. It changes annually. Right now, it's at about 73,000. So even if, previewing a little bit for where we're going to get to with the FTC rules, even if the FTC rules don't ultimately go into effect, still wanting to be really cautious about using non-competes in the DMV and thinking through. Each of the Maryland, DC, Virginia statutes don't expressly prohibit non-solicitation clauses, but we still need to be careful to make sure that we're truly drafting non-solicitation clauses and non-disclosure agreements so that they would be permitted under the law and that they're not going to be essentially masquerading as non-competes. So what you're all here for, I know, is the FTC rules that dropped in about a week and a half ago. So the origin of the rule was President Biden in 2021 issued an executive order encouraging the FTC to take a look at unfair competition that limits the mobility of workers. A proposed rule was issued in January 5th of 2023. They got something like 26,000 comments to the rule. So in the meantime, they've been going through processing that. Overall, the final rule, for those of you who participated in the webinar I did back in January of 2023 about the original proposed rules, the new rule, the final rule, looks a lot like the proposed rules. There haven't been a whole lot of significant changes. So what do we see? So the new rule was approved by the FTC on April 23rd. It will go into effect, or it is set to go into effect, 120 days after it's published in the Federal Register. That's anticipated to happen May 7th. So we're looking at a late August effective date. However, when I say it is scheduled to go into effect, there's already been lawsuits filed to challenge the effectiveness and the validity of the rule, including from a number of large organizations like the Chamber of Commerce. So there is a fairly strong likelihood that an injunction will be issued to stop the rules from going into effect, at least temporarily, and that the issue will work its way up to the Supreme Court. The likelihood of this increased when the Chamber of Commerce filed their lawsuit in federal court in Texas, in a court that is very well known for having struck down other rules and placed injunctions on other rules. Some of you may remember that the Obama administration had issued overtime rules that were frozen and placed under injunction about 2 days before they were set to go into effect back in November of 2016. So we are expecting that there's a good likelihood that the Texas court, or one of the other courts that are looking at these cases, will issue a nationwide temporary injunction that will keep the rules from going into effect as scheduled on that 120-day mark. But we certainly have no guarantees. We don't know how the court will rule. Eventually these cases might work their way up to the Supreme Court. So we're going to have to stay tuned to some extent and figure out where we're going to go from here. It may happen at the last hour. I've had clients asking me, well, when should I start planning if I have non-competes? When should I start thinking about this? I mean, starting to brainstorm and being aware of at least what's in the new rules now. That's why we wanted to do the webinar coming out of the gate here, so you can start thinking about it in the event that there isn't an injunction and the new rules go into effect. But more likely than not, there will be an injunction that will prevent them from going into effect, at least in some jurisdictions. So as far as what is in the new rules, the FTC's rules are fairly sweeping. It applies to employees and contractors and all for-profit businesses, with some limited exceptions for the banking industry. For nonprofits, for those of you who are nonprofits, just because you're listed as a nonprofit and registered with the IRS as a nonprofit does not necessarily mean the FTC is going to consider you a not-for-profit organization. There is a two-part test that they look at as far as where your revenue is coming from and what your revenue is doing to actually determine if you are a not-for-profit business that would be exempted from the FTC's authority. So really, for if these rules go into effect, it's going to be sweeping because it is covering all industries for the most part, all workers, contractors, interns, employees. And so essentially what the rule does is it says no new non-competes can be entered into after the effective date of the rule. It also says that enforcement of non-competes that were entered into prior to the effective date of the rule must stop. So those non-competes are going to be void unless those are agreements with a senior executive. So what is a senior executive? A senior executive is going to be someone who is making over $164,000. Why that very specific number? They chart it with federal wage rates. And they also need to be in a policymaking position. So this person, in order to be classified as senior executive, has to have that approximately $151,000 salary and has to be in a policymaking position with the organization. Only those existing non-competes will still be enforceable. For everybody else, any non-competes they previously signed will be void. As I'll mention, there will be an obligation to provide notice to employees who have non-competes that will no longer be enforceable. And you will not be able to be asking employees or contractors or any new business partners to sign non-competes. There are some limited exceptions. These are really for a franchisee-franchisor relationship, but it's not the franchisor and their employees. It's the franchisee-franchisor. You can have a non-compete, or you can have some non-competes in the context of selling a business. So those are pretty narrow exceptions that if this rule goes into effect, non-competes will be very difficult to still have. So what is a non-compete? The rule defines non-compete as quite broadly. It's a term of condition of employment that prohibits a worker from, penalizes a worker for, or functions to prevent a worker from seeking or accepting work in the United States with a different person where such work would begin after the conclusion of the employment that includes the term or condition, or operating a business in the United States after the conclusion of the employment that includes the term or condition. So breaking this down a bit, one big thing to note is we're talking about after the conclusion of employment. So this restriction is not going to prevent what are commonly known as moonlighting clauses. So it is not going to prevent employers from telling employees they can't compete while they are still employed by a business. Those types of restrictions will still be permitted. So you still can say to someone, you can't work for us during the day and our competitor at night, or any other business that would draw your interest and your efforts away in the middle of on your off hours. You can still have restrictions on what someone does during their working time, during the time that they're working with you and during that working relationship. These restrictions apply to what happens after they leave. So these would be the restrictions of you can't go work for someone for 6 months after you leave us. You can't go work for a competitor. You can't go start a new business. Really, the big thing to understand here is this is a functionality test. Just because you don't call it a non-compete clause does not mean it's not going to get captured in this definition. And the FTC is very clear on this in its comments to make sure that people understand, just because you call this a non-solicitation, if it is so broad and so restrictive that it really is going to prevent someone from going to work for a different person or a different entity when they leave, it no longer is going to be a non-solicit, it's going to be a prohibited non-compete. So really making sure that we're not just looking at what the title of the clause is or what the title of the agreement is, but really how it's functioning. Is it functionally prohibiting someone from going to work elsewhere, or from going to start a business elsewhere? So a few final points on the FTC rules. The FTC rules do require notice for employees who have existing non-competes that it will no longer be enforceable. So this would occur again if the FTC rules go into effect in 120 days, end of August. Employers who have employees who are not senior executives, those employees would need to be notified that, hey, you have a non-compete in the employment agreement, for example, that you signed with us, or in the larger restrictive covenant agreement you signed for us. There's a non-compete in there. Please be advised, pursuant to the new FTC rules, that clause is not going to be enforceable. We're not going to enforce that against you. The FTC has issued a sample notice of what that could look like that employers can use. There isn't going to be an obligation if you have non-competes, it is going to presumably be a fairly limited pool of people that you're going to need to provide notice to. There's The biggest challenge is going to be notice to people who've departed that are still within their 6 month or 1 year or whatever the restrictive period is, that you're going to need to make reasonable efforts to provide them with notice. However, for the folks who are, still working for you, that's going to be easy. If you have people who had non-competes back in the day, that period has expired. You don't need to follow up with them or reach out to them, but it will be important to the extent the FTC rule goes into effect to be providing notice. The rule does supersede inconsistent state law. So whereas some states, the Californias, Massachusetts, Marylands of the US have gone the direction of restricting non-competes, other states have passed statutes to essentially they've been targeted at preventing localities from implementing laws that would restrict non-competes. So some states have enacted laws basically saying employers in our state can use non-competes and that localities cannot pass laws to restrict the use of non-competes. This rule would supersede such laws that basically entitle people to use non-competes. The interesting thing, and one question I've been getting a lot, is how is it going to look as far as enforcement? What teeth does this rule have? And it's a little bit interesting for the FTC to be the one that's pushing this out. Something like this typically did not come out of the FTC is not known for getting into the weeds on employment issues typically, but there's no private right of action here. So someone cannot individually sue someone for violating the FTC's rule. Moreover, the FTC can pursue injunctive relief, but they can't issue any type of civil penalty or monetary relief for violations. So really where this is going to come into play is that employers just won't be able to enforce the agreements that they have. And to the extent they do so, the employees will have a defense. And then employees, they will not be able to sue for, in order to get violation or get any type of relief or penalties for someone violating the FTC rule, but they may be able to seek injunctive relief from a court saying, no, this non-compete is not enforceable. So usually we see non-competes, the primary times we see non-competes end up in court is the employer is trying to enforce against the employee. And that's when this would come into play. The employer goes to enforce a non-compete against the employee and the FTC's rule is standing there in the way, preventing the enforcement because they are subject to this rule. So a few other things just to be aware, because of the fact that we might see these rules placed in injunctive status, maybe they don't go into effect. It's going to work its way through the court system and it's a wait and see approach. There is also federal legislation. As I said, the FTC is a little bit of a strange source to be coming out with these types of restrictions. There have been efforts at the federal legislative level in Congress to pass laws to restrict the use of non-competes. There is the Workforce Mobility Act of 2023 is still actually pending in this Congress because the session carries 2 years. This has previously been introduced in 2019, 2021. They are bipartisan bills, though they have not taken off and really made their way out of committee. They essentially would do a lot, basically the same thing as the FTC's rules. They would ban non-competes except in the context of selling a business or transferring a business ownership. So not looking like these are going to move anytime soon, but always something we want to be mindful of, particularly if the FTC rules get struck down, there may be a greater push in Congress to take action on this. So as far as the key takeaways and items we want to be focused on before we move to questions, obviously stay tuned for more on the FTC rules. Stay abreast both of the changing federal law and changing state law, and know the law in the jurisdiction where not only where your business is operating, but where the employee is located. We have obviously more and more people who are working remotely. So being sure before you hand someone an agreement in Montana, California, Colorado, that you understand and know what restrictions might apply in that jurisdiction to the restrictive covenants you might be trying to place in an agreement with that employee who's located there. So it's not just where you and your business are physically located, it's where the employee is going to be working. And understanding there are a lot of nuances, as I said, there's a lot of different varieties of how the state laws are restricting the use of non-competes and non-solicitations. So just making sure you understand that. Ensuring that restrictive covenants are really carefully drafted, even if the FTC rules don't go into effect, you still have to make sure restrictive covenants are carefully drafted. Even if non-solicitations are still permitted. You still want to make sure that they're carefully drafted to be enforceable. I strongly recommend against using internet templates. There are a lot out there, and there are a lot of really bad ones out there that will not be enforceable. So, yes, you have someone sign an agreement, but it's not going to be worth the paper that it's printed on, because of the fact that they are way overbroad. They don't include the specifics. They don't take into account state, local jurisdiction statutes or laws. Also need to account for state common law, so what the courts have said in the state and what they are and are not willing to enforce. For example, looking at how long a restrictive covenant can last, how long can a non-solicitation provision go for, how long is reasonable for a non-compete to go for. The state courts have generally created a landscape of law on what they will and will not enforce. And so you want to make sure that whoever is drafting your agreement knows what those are, and you've drafted the agreement carefully, and also given thought to who it is we're giving that agreement to. And as we go out, the FTC rule, yes, it may or may not go into effect, but really it's emblematic of this pushback against non-competes. So starting to give some thought to alternatives to non-competes, because even if the FTC rule does not go into effect, particularly in the current labor market where employers are often fighting for employees in certain industries, we want to make sure that we are competitive. And, for those businesses that are, putting up a non-compete as part of their hiring package against someone who is not placing an employee under a non-compete, they might lose out. So there are creative alternatives to being able to ensure that you're protecting your interests with most employees that are short of a non-compete. So really giving thought to whether there are alternatives you want to pursue, or you might be able to pursue, to keep things competitive, and then to not have to worry as much about what happens if the FTC rule or a similar rule in your jurisdiction goes into effect. So with that, wrapping up, I expected we were going to have some questions. So I'm happy to take questions, and I see some popping up in the corner. So one question we had is, would you recommend waiting to make any contract changes until later in the summer, considering that there may be a nationwide injunction? Yes and no. Yes, I would wait to make any changes that are specifically targeting the FTC rule until we know more about what's going to happen. However, if you're listening to this presentation and realizing, hey, I never thought about that rule in DC or Maryland or Virginia, or I've never actually looked at whether our restrictive covenants are customized or carefully drafted, or asked anyone whether they would be enforceable, then I would recommend taking a look at them and making changes, not just targeted for the FTC, but targeted for general enforceability. So question, abbreviating it, as to what a senior executive is going to be. As I mentioned, there's that wage threshold, and it needs to be someone who's making those key decisions. Going to be a bit of a judgment call to some extent, as to, is it all the partners, who are all the partners at a law firm? Are they all in policy making positions? The answer is probably not, depending on the size. It's similar, we've seen this issue play out a little bit as far as, who's considered senior management for the perspective of who's considered an employee when you have management versus employees in an ownership structure. So really thinking about, does this person actually have a role in the decision making, or are they just one of 250 partners who have a vote, but they aren't actually involved in the policy making position of our entity? I've silenced the crowd. Let's see. Give a moment for more questions. So I will give you back some of your time this afternoon if we don't have any further questions. But again, I would emphasize that, really taking the time to understand and take a look at the agreements you're using, whether or not the FTC rules go into effect, because we want to make sure that, as well-drafted restrictions can be, they can be extremely useful for protecting the business interests, but they're only as good as making sure that they are actually enforceable and that they're carefully thought through, so they don't place us at either a competitive disadvantage or in a situation where we have agreements that we cannot enforce. So with that, we're always happy to answer questions. Yes, for those who are asking, the slide deck will be sent out. We will be recording this, so if you want to listen to it again, go through the slides again, and don't hesitate to email me with any questions. I will put up my email here for those of you who don't have it. But feel free to shoot us email. You know where to find us, and we look forward to working with you to help you navigate this. And of course, we will be keeping you posted on what's going to happen with the new FTC rules. Thank you all for participating.